Hello, this is Kent Holland. It's my pleasure to present ConstructionRisk.com report, the March 2013 issue. Today we have 4 articles, 4 different cases that we'll discuss very briefly. If you would like to have greater detail, please read the full articles on the website itself or in the newsletter. The first case deals with an implied warranty of habitability on a home sale. And the article is entitled, Implied Warranty of Habitability is Extended Beyond the Initial Home Purchaser to a Second Purchaser. And in this case, the purchasers of a new home from a home builder sold that house 3 years later, and 2 years after that new purchaser bought the house, they discovered water infiltration around their windows. And this caused mold and other problems that required substantial remediation. They then filed suit against the builder, asserting a breach of implied warranty of habitability. Now, typically, the builder owes that warranty, whether it's express or implied, only to the purchaser that buys the house from the builder. And in this case, the builder moved for summary judgment, saying, I have no privity of contract, the second owner can't sue. But the Supreme Court of Pennsylvania held that the implied warranty of habitability extends to the subsequent purchaser of the home. Now, the reasons that the court ruled that way included, first, the court rejected the builder's argument that this would lead to unlimited liability against home builders. The court looked at it and said the homeowner still has a burden of showing that the alleged defect was latent, not patent. In other words, it wasn't obvious, it wasn't something that the original owner should have seen, but rather it was something that could only be discovered much later when the damages actually started to reveal themselves. Next, the court looked at it and said the homeowners still have to bring their claims within the statute of repose period of the state, and in Pennsylvania that's 12 years. And so the court said it's really not unlimited liability, there's still a maximum time of 12 years in which to bring the suit. Now, the court's reasoning is so significant, I'm just going to read it. I'm going to put the slide up here that shows the quote that I'm going to be reading from. Quote, a second or subsequent purchaser is entitled to the same assurances as the original purchaser that the home the builder has constructed is habitable for human living. By its very nature, the implied warranty of habitability shifts the risk of latent defects from the initial homeowner to the builder, because the builder is a party with the necessary expertise that the initial purchaser does not possess. When a home is sold from the initial purchaser to a second purchaser, neither party to that sale possesses the expertise that the builder does. Close quote. The next case is entitled Common Law Indemnity is not owed by an architect to the developer, where the developer's own alleged negligence was the subject of the suit by the owner as well. So in this case, there was a project owner, the YMCA, sued a developer, Bovis Lend-Lease, for breach of contract, alleging that it had wrongfully approved a defective design that had been proposed by the owner's architect, and that Bovis, who was acting more or less as a construction manager, had approved inferior or improper construction materials. Now, Bovis filed a common law indemnity claim against the owner's architect. Now, this architect had a contract directly with the owner, had no privity of contract, no relationship with Bovis. The court held that Bovis could not pursue the indemnity claim because the owner's complaint against Bovis was not limited to merely vicarious liability issues, of where Bovis was vicariously liable for actions of others, such as the architect, but rather the owner's complaint contained actual allegations that Bovis failed to perform some of its own contractual obligations. The court's explanation was as follows, quote, since the predicate of common law indemnity is vicarious liability without actual fault on the part of the proposed indemnity, it follows that a party who has itself actually participated to some degree in the wrongdoing cannot receive the benefit of the doctrine. Close quote. A second issue that was decided in favor of Bovis, however, was one where the court held that the owner's claim of unjust enrichment on the part of Bovis for fees that it had previously paid to Bovis for its allegedly defective service had to be dismissed. And this was because the court said, look, you've already got a contract with Bovis, you have to recover only under your contract, and you can't have this equitable relief such as unjust enrichment or quantum merit when you have a written contract. So what the court said was, quote, recovery for unjust enrichment is barred by the existence of a valid and enforceable contract, close quote. The case site on this was Genesee, Wyoming, YMCA versus Bovis Lend-Lease. The next case is entitled, or the article is entitled, Indemnification Clause in a Prime Contract is not incorporated by reference into a subcontract under New York law in the absence of express agreement to do so. Now, this is an interesting case because there was a subcontract that had an incorporation by reference clause of the prime contract, and the prime contract included an indemnity clause between the prime and the project owner, and the prime intended to flow that indemnity obligation down to the subcontractor. But in attempting to do so, the court dismissed the indemnity claim, holding that in New York, the only things that will flow down when you say, I'm going to indemnify, I'm going to flow down, I'm going to incorporate by reference, would be a very limited group of items. Specifically, it would have to include things related to the scope, quality, character, and manner of the work to be performed by the sub. Close quote. Anything other than that, like indemnity provisions, don't flow down unless the subcontract specifically says so. So this is a peculiarity of New York law, which is interesting because for those of us who may have from time to time the opportunity to be reviewing contracts in states other than those where we might be licensed to practice law, this is a good eye-opener as to why it's important to have a local counsel. And New York counsel have explained to me before this very important rule that if you want to flow down things in New York, you need to be very specific which clauses you are flowing down. And if you are practicing from out of state, reviewing a contract, you might not know that. Let me hit some of the highlights of this. In this particular case, there was an employee of an electrical subcontractor that was injured on the job site. And he sued the project developer, the prime contractor, and others. And those firms in turn filed a third-party claim against the sub-sub, claiming that the right to common law indemnity existed as well as contractual indemnity. Now the common law indemnity was dismissed by the court because an employer can only be held liable for contribution or indemnity under New York common law if there's been what is called a, quote, grave injury, close quote, to the employee. And in this case, the court looked at the injuries, which, although serious, were not deemed to be grave. Therefore, no common law indemnity. And then again, as to the contractual indemnity, the court said there's no written agreement that required the sub-sub to indemnify others, and that although the prime had an indemnity provision, that provision simply did not get incorporated by reference into the subcontract under New York law for the reasons explained. This case is Lawrence Persaud, P-E-R-S-A-U-D, versus Bovis Lend-Lease. The last decision that we talk about in this newsletter is entitled Spoliation of Evidence. The contractor had no duty to preserve a concrete I-beam that fell from a bridge with several laborers standing on it, fell into a creek, and caused injuries. Now in this case, several employees of a contractor suffered injuries when the concrete I-beam that they were standing on while installing a handrail on a bridge collapsed and they fell into the creek below. And the Illinois Department of Transportation, as well as the U.S. OSHA, did an immediate same-day inspection of the accident site. And they made certain determinations and didn't conclude that the beam broke and had a defect, but rather it appeared that it may have somehow twisted on its mount to the side, and in that twisting motion it fell to the creek below. Well, after making that determination, they left, and the next day the contractor came back out and destroyed the I-beam by breaking it up with a hydraulic hammer and used it as riprap. And he said that he did that based on a DOT engineer from the state telling him, look, you've got to get rid of this concrete, break it up, use it as riprap to prevent scouring of the creek bank. Well, sometime later, the laborers filed suit against the manufacturer of the I-beam, and they also sued the designer of the bearing assembly that supported the I-beam on the bridge, and also they sued the contractor, their employer himself. And the Illinois Supreme Court, among the things that they argued against their employer was that you destroyed the evidence. That's called spoliation of evidence. And the other firms that were sued likewise brought third-party claims against the contractor saying, spoliation of evidence. You've destroyed the evidence. How can we defend ourselves? Now, the Illinois Supreme Court found that there was no evidence to support the existence of any duty of the contractor to preserve that I-beam. And the reason the court concluded that was, one, there was no agreement, contract, or statute that required the preservation of the I-beam as evidence. Two, merely by doing its own investigation of the accident, as this contractor had done, that included even photographing the site and the I-beam after it fell, this did not constitute a voluntary undertaking to preserve the I-beam for the contractor's own purposes. Because that was one of the theories, that if somehow the contractor had voluntarily taken on any responsibility for preserving that I-beam, he had to keep maintaining it. The court said no. What it did in its investigation did not constitute a voluntary undertaking to preserve. And the third issue, the court determined that there was an employer-employee relationship, but that relationship did not in itself constitute a special circumstance that would impose a duty on an employer to preserve the potential evidence. The court said, quote, a plaintiff, in order to establish an exception to the no-duty rule, must meet a two-pronged test. The first test is that the plaintiff must show that an agreement, contract, statute, special circumstance, or voluntary undertaking has given rise to a duty to preserve the evidence. Under the second test, the plaintiff must show that the duty extends to specific evidence at issue by demonstrating that, quote, a reasonable person in the defendant's position should have foreseen that the evidence was material to a potential civil action, close quote. Well, in this case, the contractor said, well, yes, I knew there were injuries, and I knew that they would be entitled to workers' compensation, but I wouldn't have realized they were going to file suit against anybody else. And so the contractor argued that it did not anticipate any litigation, and the court apparently was satisfied with that. That wraps up today's newsletter. I hope you enjoyed these articles, and will join us again for future issues, both video and the written newsletter. All the past issues, all the way starting back in 1999, are available on my website at www.constructionrisk.com. And you can always contact me, Kent@constructionrisk.com. Again, this is Kent Holland, and it is my pleasure to be with you. Look forward to joining you again. Thank you. Goodbye.